Wonderful. Well, you know me from this morning. I'm R.D. Rai. I'm a professor here at the law school. And I'm not Kate Bartlett, who is listed on your program as the person to do the introductory remarks for Judge Dyke. But unfortunately, she had another scheduling conflict. But I'm delighted to be able to take the opportunity to introduce our keynote speaker. As many of you know, we have not a long history because this symposium has only been going for about 6 years, but we have a history of having notable Federal Circuit judges giving our keynote talks, and this is yet another situation in which we're fortunate enough to have a very esteemed Federal Circuit judge. Judge Timothy Dyke. He was appointed to the Court of Appeals for the Federal Circuit by President William J. Clinton in 2000. And prior to that, he was a partner at a number of different law firms. He was a partner at Wilmer, Cutler, and Pickering until 1990, and then a partner and chair of the Issues and Appeals Practice at Jones Day from 1990 to 2000, at which point he was appointed by President Clinton to the Circuit Court. He served as a clerk to Chief Justice Warren and also a special assistant to Assistant Attorney General Louis Oberdorfer in the 60s. So he has a wonderful pedigree, graduated from my alma maters, Harvard College and Harvard Law School. So of course I think that's a wonderful pedigree as well. And he has been both a practitioner, a judge, and a law professor. He served as an adjunct professor at Yale Law School, University of Virginia Law School, and Georgetown. And I have to say that I take a particular delight in being able to introduce him because he is one of the judges on the Federal Circuit who takes administrative law very seriously, which is sort of a pet peeve of mine. And in point of fact, in a 2002 decision called Deathmers, he admonished some of his colleagues for not taking seriously the Supreme Court's decision in Dickinson versus Zerko to tell the Federal Circuit that their review of the PTO was court agency review, and I've prominently cited that dissent in many articles I've written. So I'm particularly delighted to have him here for that reason. Without further ado, he told me that I had to keep this short, so I will keep it short. There are many more things to say, but Judge Dyke is going to speak on the Supreme Court and the Federal Circuit.
Avoid tripping on this wire here. Okay. Thank you very much. It's a great pleasure to be here this afternoon. And before I begin, I should make clear that the views I'm expressing here are solely my own. They don't reflect the views of any of my colleagues on the court or, of course, the court itself. And at the conclusion of my speech, I'm going to welcome questions. Hopefully we'll have time for that, though, of course, I ask that you avoid asking me how we're going to decide any particular cases that you have pending before the court. I think, as you've heard earlier at this conference, and has been true of discussions at many other conferences as well, this is a time of some turmoil in patent law, turmoil and a great deal of interest and new focus. And criticism has focused, of course, on the Patent Office for granting, in the view of some, too many questionable patents. And criticism also has been focused on the court system, where some people think we've gone from a system that Justice Jackson characterized as being one in which the only valid patent was one that the courts hadn't gotten their hands on, to one in which the courts were, and particularly our court, was unduly favorable to patents. And to some extent, the argument has been made, and it's probably a vast oversimplification of what the Supreme Court is doing, but some people have viewed the Supreme Court as stepping in to redress the balance, to shift the balance away from patent holders. For example, by restricting the doctrine of equivalence, by grading greater opportunities to raise invalidity issues by declaratory judgment, by eliminating the presumption that an injunction will issue in patent cases, by giving a wider scope to the FDA-related exemption in 271E1. And these and other cases are seen as really having a fundamental change in the landscape. Well, it'll be interesting to see once KSR comes down whether these same arguments are going to continue. My guess is that they are. Now, the turmoil has resulted in what's a very desirable dialogue about the future of patent law. This has been, in general, very helpful, though to some extent it's been marred a bit by sometimes ill-informed and somewhat naive proposals for radical change in the jurisprudence, and on the other hand by a sort of myopic and stubborn defense of the status quo. But I don't think it's fair to say that that's an overall characterization of the dialogue that has taken place. I think the dialogue is a highly desirable one. And of course, as a sitting judge, I'm very reluctant to get involved in the substance of any of the patent issues that are discussed at these conferences, and I'm sure that's true of my colleagues as well. And so I'm going to confine myself to a discussion of the process. And I do think the process is important because, as Professor Duffy and many others have pointed out, the Supreme Court has taken a greater interest in the patent area in recent years than it has for a long, long time. Now, since the creation of the Federal Circuit in 1982, my count is that the Supreme Court has agreed to hear 19 patent or patent-related cases coming from the Federal Circuit. And I'm not including within that total the so-called GVR cases where the court is remanding for consideration in the light of another Supreme Court decision. And I'm not including the decision in Benito Boats on preemption, which came from the Florida Supreme Court. I'm confining myself to decisions where the Supreme Court granted review to consider a decision of our court. In the first 10 years of our court, the Supreme Court only reviewed 3 Federal Circuit patent decisions, and one of those was decided summarily without oral argument. And then in the second decade, the pace increased a bit, with the Supreme Court agreeing to hear 9 cases, which is still an average of fewer than 1 a year. And in the past 5 years, particularly the last 3 years, Supreme Court has granted certiorari in 7 cases. So you can see just from the numbers the increased interest. In the 16 cases that have been decided in the last 25 years, the court has affirmed in 4, it's substantially affirmed in 2 others, it's reversed in 2 while essentially agreeing with the Federal Circuit's ground for decision, and it's reversed or remanded in 8 others. Now, some people have suggested that that's not a particularly good record for the circuit, but I'm going to leave to others to debate that particular question. The interest of the court has been reflected not only in the number of cases, but also in the subject matters addressed. They've gotten into questions of claim scope in Markman, Festo and Hilton Davis, and invalidity in KSR, and patentable subject matter, and the metabolite case, extraterritoriality in the pending AT&T case or Microsoft case, whatever you want to call it, enforceability in eBay, antitrust in Illinois Tool. One notable area that they haven't addressed is the relationship between the court system and the patent office. Not since Zerko has the Supreme Court gotten into that. But with all this activity, there are still a lot of issues unaddressed, and my own view is that the Supreme Court's likely to continue to hear significant numbers of patent cases in the years to come. And this is so, even though I don't think, unlike the period in the 40s and 50s, where there was a great division within the Supreme Court as to the direction that patent law ought to be taking, that unlike that period, there doesn't seem to be the same ideological division within the Supreme Court. Now, this increasing interest by the Supreme Court in patent law has been viewed by some people as undesirable. And I guess the theory is that the Supreme Court has no particular expertise in patent law and that it threatens to upset a carefully crafted balance. I guess a carefully crafted balance that our court has produced. My view is not that. My view is that the Supreme Court's increasing role in the patent area is highly desirable. And it's a very welcome, and indeed it's a necessary development. And I think that's so for several reasons. First, I think the courts have a special role to play in the development of patent law. The Constitution, of course, confers the authority in the patent area in very broad language. And since the beginning of the patent system at the beginning of the country, the patent statutes have been written at a level of generality, which is almost the same as the Constitution itself. And we do have exceptions like the very detailed provisions of the Hatch-Waxman Act, but by and large, the patent statutes are very, very general in nature. To paraphrase that famous line from Judge Rich, the patent statutes provide few blaze marks for the courts to follow. And this landscape, of course, is a familiar one to practitioners of administrative law. In the modern era, Congress has frequently legislated in general terms in a whole host of areas simply because it lacks the time, the resources, or the inclination to provide detailed guidance. And now in most areas, the solution lies in the familiar Chevron doctrine, because you have an administrative agency that's responsible. And of course, under the Chevron doctrine, the courts defer to the expertise of the agency. The agency engages in rulemaking or adjudication and articulates the policies, fills in the interstices in the statute, converts the general congressional guidance into something particular. And once the agencies have done this, the courts are obligated to defer if the statutory language is ambiguous, which it often is, and if the agency's interpretation is reasonable. That's the familiar two-step Chevron process. And rightly or wrongly, we don't have that situation in the area of patent law. And that's a very, in my view, a very remarkable feature of the patent system. At least under the decisions of our court, the Patent Office has no substantive rulemaking authority, and no Chevron deference is due under our court's decisions to the Patent Office interpretation of the statutes. And at the same time, Congress hasn't conferred on the Patent Office a significant role in the litigation process with respect to issues of claim construction, validity, enforceability, patentable subject matter, et cetera. Now, to some extent, the reissue and reexamination process is an adjunct, can be an adjunct sometimes to litigation. But by and large, the system is a court system without a great deal of involvement of the PTO. Now, that's not to suggest that the PTO doesn't play a very important role in the patent system. It does, but it's not the same role that administrative agencies play in other areas of the law under congressional statutes. And the consequence is that the courts have essentially been charged with the task of developing a common law of patents, much as the courts have been charged under the antitrust laws with developing a common law of antitrust. And we'll come back to that analogy a bit later. So it strikes me that in this environment, with this essentially common law responsibility, the Supreme Court review of patent decisions is even more important than it is where the statutes are more detailed or where you have an administrative agency able to articulate in more detail the rules that it should apply. Now, it's curious that in the 25 years of our court, that the Supreme Court's only rarely granted review of what might be called these common law patent issues. Of the 19 cases, by my count, 7 have involved what I would consider procedural or jurisdictional issues, the standard of review for the PTO, Zerko, the scope of the declaratory judgment jurisdiction as in MedImmune, standard for injunctive review in eBay, scope of our appellate jurisdiction in Bernardo and Christensen, Rule 52, and mootness issues in Cardinal. And the courts addressed one antitrust case in Illinois Tool and an 11th Amendment case in Florida Prepaid. And in these cases, the Supreme Court's role has generally been to bring patent-related jurisprudence into line with the jurisprudence that applies in other areas outside of patent law. I mean, there are other things the Supreme Court has done in these cases, but that is a principal thing that the court has done. 4 of the cases have involved the interpretation of specific statutes. The FDA-related provisions, the Plant Variety Protection Act, 271F. So once we get done with putting those categories aside, we're only left with 6 cases in the last 25 years that the Supreme Court has agreed to consider the basic common law patent issues. In PAF on the on-sale bar, and Markman concerning claim construction, Hilton Davis, in Festo involving the doctrine of equivalence. And then the metabolite case, which of course was dismissed as improperly granted, and the pending KSR case involving obviousness. And I think one might ask whether the Supreme Court should play a greater role in considering some of these common law issues than it has over the last 25 years, and whether maybe it will do that. Now, the second reason that Supreme Court review is important in this area relates to the old Supreme Court jurisprudence. We still are citing and dealing with Supreme Court cases that are 100 years old in the patent area. That's not true in very many other areas of the law. But the problem is that a lot of that jurisprudence tends to be fairly outdated and a bit difficult to apply to modern conditions. So perhaps there's an important role for the Supreme Court to play in trying to update its jurisprudence in the area of patents. Now, the third reason that I think Supreme Court review is important is because of the lack of inter-circuit cross-fertilization. Of course, in 1982, in order to achieve uniformity, the Congress created our court. And we have virtually exclusive jurisdiction, though under Vernado, there's a sliver of jurisdiction that you could result in patent cases going to other circuits, but that doesn't happen very often, and it may be that even if it does, that the other circuits are going to be obligated to apply federal circuit law rather than develop their own law. Now, I'm not suggesting that there's anything wrong with this, with having the jurisdiction assigned to a single circuit. I disagree with Professor Duffy and others who've suggested that the jurisdiction ought to be shared with other circuits. There's a great value in achieving uniformity. But at the same time, I do think the fact that the cases come to a single circuit, that there isn't the opportunity for inter-circuit conflict, does create a special need for Supreme Court review in the patent area. Now, a fourth reason that I think Supreme Court review is important is that the stare decisis effect of the Supreme Court's own decisions, of our own panel decisions, of our own bank decisions, really constrains panels of our court in deciding patent cases from developing and changing existing doctrine. That can really only be done through in-bank decisions or decisions of the Supreme Court. And then the final reason that I think the Supreme Court review is so important is just the sheer importance and complexity of patent law. And it really is a very, very important aspect, patents, intellectual property, very, very important aspect of the national economy. And it's an area that's worthy of the Supreme Court's attention just because of that fact. Now, given the likely continued interest of the Supreme Court in the area of patents, I'd like to raise some questions about the process. And I'm not, by raising these questions, necessarily suggesting answers, but I do think raising the questions and leaving it to the Academy and the bar to debate them further may be useful. The first question is whether the Supreme Court should apply stricter standards in patent cases to make sure that the issues have been raised initially with the Federal Circuit. It's a strange question to have to ask because, of course, it's bedrock law that issues not raised below generally will not be considered by the Supreme Court. And you can cite many, many cases in which the Supreme Court has refused to consider issues that weren't raised below. And yet we have this anomaly in the metabolite case where the issue was not raised below. Ultimately, the court dismissed the case as improvidently granted because the issue had not been raised below. But at the same time, we had a dissent from the dismissal by 3 justices who felt that even though the issue hadn't been raised below, who cares? You know, the issue had been briefed thoroughly, and they thought that it wasn't worth the extra time, the cost, and the uncertainty to require further proceedings. And most recently in the MedImmune case, the court faced a dissent from Justice Thomas, who asserted that the issue, the contract claim, had not been properly raised in the first instance, and the majority said, well, it had been, but even if it hadn't been, sort of who cares, you know? It's futile to raise the issue before the Federal Circuit because this was a challenge to well-established law. Now, I don't know how far that might go, but one might ask whether it's perhaps a little inconsistent on the one hand to speak of the value of the views of the Federal Circuit on some of these issues, as the Supreme Court has done repeatedly, and not to apply a strict standard requiring that the issue have been raised below. And that leads to the second question that I have, and that is whether the Supreme Court, our court, and the bar generally should view in-bank consideration by our court as a useful predicate to review by the Supreme Court. And this caused me to go back and look at what's happened. And interestingly, the Supreme Court in recent years has routinely taken patent cases that have not been considered by our court in bank. Not a single one of the Supreme Court decisions after the first Festo in bank decision in 2000, by my count, has been from a Federal Circuit in-bank decision. In some cases, including KSR, which is pending, the issue hasn't been even raised in an in-bank petition for reconsideration. And this can be contrasted with the preceding 6-year period where half of the Supreme Court patent cases came from in-bank decisions of our court. Now, when the Supreme Court takes these patent cases and it feels that it doesn't understand that we haven't articulated a basis for the rule, which is understandable to them, they get frustrated, you know? And those of you who've read the transcript of the Supreme Court argument in the KSR case can see that. You know, there were references to the underlying legal principles as being gobbledygook. You know, it gets better. Federal Circuit jargon and worse than meaningless. And Justice Breyer said he'd read the opinion, the briefs 15 times, and he still couldn't understand what was going on. You read the Microsoft AT&T argument from earlier this week, and it's not quite as bad, but at the same time, there is a problem about the dialogue between the lawyers and the court. And you know, you read the transcript and you say, this is really not as good communication about these issues as you might like to have. Now, to some extent, I think that the failure to have more in-bank review as a predicate to Supreme Court action, to some extent, the fault lies with the bar. And it strikes me that the bar is remarkably reluctant to challenge existing Federal Circuit precedent, either in the district court or within our court. And I had a conversation with somebody in the bar the other day at a dinner. And he said, well, why don't you raise these issues? If you think that our jurisprudence is wrong, why don't you raise these issues in the district court and argue it? Oh, can't do that. The district judge would be very angry at me if I did that. And I'd lose my case even before I got to the Federal Circuit. So I think that there's a bit, perhaps, of reluctance to do this. Now, that's not to say that people aren't filing petitions for rehearing in our court. Every case, practically, has a petition for rehearing. But the arguments that get made in the petitions for rehearing typically are that the decision of the panel is inconsistent with 25 years or 20 years or whatever it is of Federal Circuit precedent. And it's only when the door closes on further review in our court that it seems as though there's a discovery that the court's approach, and this isn't true in every case, but it is true in many cases, that suddenly it's discovered that the decision is inconsistent with the Supreme Court authority, or it's wrong as a matter of policy, or it's inconsistent with law outside the patent area. And what's surprising is that these issues are not routinely raised in petitions for reconsideration. And this is a bit surprising to people who've been active in the Supreme Court bar, because in other areas, a careful petition for rehearing, raising the issues that people want to take before the Supreme Court, exploring the policy implications of those issues with the Court of Appeals, is seen as a very important predicate to review in the Supreme Court. Whether or not the petition is granted, it can result in dissents or concurring opinions or a further articulation of the rule by the circuit, which will help get Supreme Court review, help define the issue for the Supreme Court. I don't see that happening to the same extent in the patent area. Now, so I've been suggesting that there's a bit of a criticism that could be directed against the bar. But I think it's also true that some of the responsibility for this situation, that is the absence of in-bank consideration as a predicate to Supreme Court review, can be laid at our own doorstep. Our court has considered very few patent cases in-bank in the past few years. By my count, in the past 5 years, we've terminated about 6,700 appeals. And some 1,500 of these have been in patent cases. And in those patent cases, we've issued about 480 precedential opinions. But during this time, that is the last 5 years, only 4 patent cases were argued in bank, and that was Phillips, Knorr-Bremse, Festo, and Johnson & Johnson, though we've recently granted in-bank review in one other one. And 2 other in-bank decisions were rendered without oral argument. In any event, whatever the cause of this lack of in-bank consideration, whether the Supreme Court should do more about it, whether the bar should do more about it, whether our court should do about it, the fact is the Supreme Court's not getting the benefit of in-bank consideration in many of these cases before the court considers it. And I think that the process probably is the loser as a result of that. Now, the third question that I wanted to raise is whether the Supreme Court should finally resolve patent cases that it decides to hear. And what happens frequently in these patent cases that the Supreme Court does take is that the Supreme Court articulates a general principle, and then it leaves it to our court to both elaborate the rule in new individual cases and to apply it to the individual case before it. And I can give you many examples of that. Now, every appellate judge is acutely aware of the discipline and the increased clarity that comes from applying a general principle to the facts of a particular case. And that's, of course, one of the reasons the courts are reluctant to follow dictum in earlier cases. And I think it could be argued the Supreme Court might be better served in some of these cases by grappling with the application and the meaning of the particular rule that they're announcing in the context of the individual case, as the court did in PAF. And that if it did so, there might, the rulings might be better understood by the bar and the lower courts afterwards. I mean, I'm not saying that Supreme Court doesn't have to announce general rules. Clearly it does. It's in the unique position of being able to take only a handful of cases in any year or period of years in the subject matter area. The Supreme Court has to announce broad principles, but I'm just raising the question of whether it might not be better served by developing those rules in the individual cases that it has before it. The next question I have is whether unanimity is maybe a mixed blessing in the Supreme Court patent cases. In the past 10 years, by my count, 9 out of the 14 Supreme Court patent or patent-related cases were unanimously. And in fact, every single one of the cases that involved, might be said to involve the common law of patents, was unanimous. The close cases, where there were significant numbers of dissents, were all removed pretty much from substantive patent law. They involved procedural issues, sovereign immunity, et cetera. And again, anyone who's been a judge knows from hard experience that there's a great value to a dissent. And as Justice Brennan once said, the dissent is more than just a plea. It safeguards the integrity of the judicial decision-making process by keeping the majority accountable for the rationale and consequences of its decision. Now, in the patent cases, maybe we're not dealing with the kind of cosmic issues that Justice Brennan was referring to, but again, I think you could ask whether the Supreme Court might be better if there were a livelier debate within the Supreme Court itself about what the rule should be. A final point I'd like to raise is what the role of the Solicitor General should be in these patent cases. The Supreme Court plainly is placing great reliance on the Solicitor General in patent cases that come before the Supreme Court. You can see that from their requests for the views of the Solicitor General repeatedly when they have patent petitions that they consider to be significant. You can see it when they're deciding the cases on the merits. They refer to the views of the United States, not always accepting the views of the United States, but taking the views seriously. Now, that, of course, happens in other federal statutory areas. But again, this is kind of an odd situation because you don't have a federal agency with responsibility for the substantive law. So you get, in these cases, the views of the United States. It's not entirely clear what role the Patent Office plays in framing the views of the Solicitor General. It's not clear whether the views of the Solicitor General reflect the views of the agency charged with developing patent policy, to the extent that it is charged with that, or whether it's just the views of the Solicitor General or of the Civil Division. But whatever it is, it would seem that the Solicitor General is very influential. One can raise a question as to whether the Solicitor General, in fact, has too much influence in this process. I'd like to close with a comment about the dialogue that takes place between the various participants in this process of developing patent law. One important component, of course, is the private bar. And I have said this before, and I will keep saying it. I think in these landmark cases, now I'm not talking about routine cases that come before the Federal Circuit, and most of the patent cases are routine. But in the landmark cases that come before our court that may be destined for the Supreme Court and that may make new law, it's important for the private bar to recognize that patent law is not divorced entirely from policy. You cannot answer these questions simply by citing cases and saying this is what the rule is. There's a kind of mechanical quality sometimes to the approach to the patent law. And the courts, the Supreme Court and our court, are the loser on that. I mean, when you take a case to the Supreme Court, and you can tell this from the oral arguments in these cases, the court wants to know what's the reason for the rule, you know? Why is this situation the same as or different from some other situation which may seem to be similar? What's the appropriate stopping place for the rule? What are the adverse consequences that would flow from adopting this rule or not adopting this rule? And those kinds of issues need to be presented, need to be answered when you take a case to the Supreme Court, and I think they need to be addressed more frequently when people bring these landmark cases before our court. The second participant in this process of development of the patent law is the private amicus brief. And when we do have in-bank cases, we are deluged, as is the Supreme Court, with amicus briefs. The problem is that the briefs filed by the associations, by the law firms, you know, often are saying, well, don't decide anything, you know. This is the theme. Don't decide anything, or we can't provide guidance. Now, you know, you understand that associations have conflicting interests. We don't have a bar which is, you know, half the bar represents patent holders, the other half represents accused infringers. By and large, firms represent both. And it's understandable that it's difficult for the associations to get their members to take positions on these issues. Some of their members in particular cases may have one point of view, and in other cases other points of view. But it's quite unfortunate, I think, for the development of the patent law that there has been such great reluctance to take a position in these amicus briefs and tell us what we ought to be doing. We would benefit from it. The third participant in the process, of course, is the government. Now, while the government is very active in the Supreme Court in these landmark cases, the government is not active in our court in landmark cases. And I remember famously in the Festo in-bank argument where the government filed an amicus brief, and it was given time to argue, and the government got up and we asked them what their position was, and the government had no position. That's unfortunate. If the Supreme Court benefits from their help, which it does, we would benefit from greater help from the government as well. And finally, I will get to the academics. Now, Judge Harry Edwards wrote a famous article criticizing the Academy for being divorced from the real world. And a lot of judges really like that article. I think it's a very good article. And you know, you look at the law reviews, and too often the articles are really theoretical. And there seems to be the regression analysis is the favorite thing. Lots of regression analysis. I look at these articles and I say, what am I supposed to get out of this? And the answer is mostly, maybe it's a failing on my part, I don't get much out of them. And then there are the empirical articles, which are useful too, but they don't help us to decide cases. What we really need are more law review articles that really address the hard analytic issues that tell us, you know, here's a line of doctrine that, you know, should be modified, and this is the way it ought to be modified. And instead, when we do get the analytic pieces, it's, you know, that we should chuck overboard some entire area of jurisprudence, which, you know, maybe the academics think that would be useful, but it's not what's going to happen, you know. If you're going to help us, we need to have a more nuanced, a more limited suggestion for change in doctrine. And then, you know, I do think that it's a great thing for academics to become involved in litigation because it serves as a great counterpoint to this tendency to be overtly theoretical, because the law schools all want to be like the English departments, you know, like theoretical in nature, and, you know, so they're respected by their fellow academics in the Graduate School of Arts and Sciences. But so participating in litigation is a great counterweight to this tendency. But, you know, I worry a little bit about that it can be overdone also. And I hope that the academics aren't leaving their best work for the amicus briefs that they file with us, you know, and I hope that their best work comes out in the law review articles, and I sometimes worry a bit if there's too much involvement in litigation by the Academy that we end up with a loss of objectivity. In any event, those are my views. I don't know how much time we have left for questions. If we have a couple minutes, I'm happy to take them. I thank you for inviting me here today.
We have about 15 or 20 minutes for questions.
Sure.
Okay. All right. So you won't be accused of
well, I don't know.
Well, as usual, the professor has his hand up first. So, Professor Duffy.
Judge Dyke, I think it was the second question you had about should en banc review be viewed more as a necessary predicate to Supreme Court review. And in discussing that, you said that the bar is reluctant to raise sort of more theoretical issues at the Federal Circuit. And I've talked to practitioners too, and I get the exact same response that you got. But I've racked my brain to try and come up with some sort of way to, some sort of structural solution. I mean, you can't just keep shaking people in the bar and say, no, 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 even if you lose your case at the district court, it's for the good of the system that you raise those issues despite the district judge who's going to be upset with you, and perhaps the Federal Circuit who might say, oh, we've crossed the Rubicon on that a long time ago, we're not going to rethink that. Is there, now I propose the structural solution, which I understand that, but I'm willing to, I'm wondering, are there other more realistic structural solutions to try to get the incentives for people to raise issues or to file meaningful en banc petitions, as you suggest? I mean, the statistics, as you said, suggest that people don't file en banc petitions because they actually have a greater chance on the statistics of getting cert, oddly enough, than getting en banc review. So I'm wondering what are the structural solutions that maybe the bar could institute to, or academics, what could be done to the system, assuming that we keep a single intermediate appellate court of appeals?
Well, I think, well, first of all, that recognizing that this fear of the judges being irritated is not well-founded. I mean, I think it's common in cases that seem to raise significant issues for people to say, look, I know that what I'm arguing here on page 56 of my brief is not consistent with existing law. I don't expect you to adopt my suggestion. I know you're bound by circuit precedent, but I'm raising this so that I can preserve it for appeal. So just, a more traditional approach to reserving some of these issues. I think another thing, and I've been told that this is a problem, I don't know whether there's a rules change or an approach that could help with that, and that is the short period of time for filing petitions for rehearing, which I'm told most people doesn't allow enough time to develop amicus support for a broader consideration of the issues. And once we grant in-bank review, there's enough opportunity to do that. But as we all know, one of the most important roles of the amicus brief in the Supreme Court is at the cert stage rather than on the merit stage. And we'd probably benefit from more amicus briefs at the stage when people are seeking in bank, and maybe something can be done about time limits in that respect. I don't know.
Mr. Reichman.
Well, it's very refreshing to hear your call for more policy consideration. But
I had to say that just a little bit.
it's very refreshing to hear your call for more policy consideration. I think that is a very good thing and a very positive statement. But I don't think your court has been giving that impression that it welcomes that sort of thing for very long, or for perhaps from all of its members. So I hope that this reflects a change, perhaps partly due to the greater interest of the Supreme Court. And I hope it paves the way for a more healthy relationship. But I think part of the blame does lie with a certain reluctance of the court to consider policy issues. And I think that does also tie into the relationship with the literature. Because while it's true that in some areas of the law there is a lot of theoretical literature which one may ask what is its direct relationship, and I think that still plays a very important role. It's not my impression that the literature in the patent camp has gone that far. Often it's dealing with very serious trends, very serious economic implications, very serious policy implications of a whole series of decisions and of certain approaches, which the court in its own action seems absolutely unwilling to consider. American literature of the last 5 years in particular has been very rich in looking at the ultimate policy applications, implications of having too many patents on cumulative and sequential innovation, what I call slivers of innovation, too many bad patents out there, too much money being spent. There have been some very wonderful studies about the net aggregate loss from litigation as opposed to gains from innovation. There's one group at BU which has detected a 3% net loss looking at the period up to 1997. And I think that it's very important that the court itself engage in its own self-scrutiny of what are the effects of its decisions, because they are looking at it perforce case by case against this higher and I find very illuminating literature. I can say that because it's not my own writings in the patent area very often in domestic patent law, but I find it very good. So I would just hope that your statements here today reflect a change and a new interest in this literature, which I think would benefit and would help you.
Well, let me comment on that. First of all, I'm not, as I mentioned at the beginning, speaking for my colleagues. I got to speak for myself. But in suggesting the importance of policy considerations in the development of the law, I think there's a line, and I think that line would be drawn in very different places by the courts and by the academy. There's only, some of these articles and are asking us, suggesting that we consider, economic trends and empirical data, which seem to be more appropriately addressed to the legislature rather than to us. And while the academy might believe that we should be taking into account these trends, I think that I wouldn't agree that we can do that to the same extent that the academy has urged. Now, one of the interesting things here, and maybe there's an article about this. I'm hoping that this spring, Chief Judge Boudin is going to talk to us, perhaps at our annual dinner of the Rich Inn of Court about this issue. But in the antitrust area, which is, I think, comparable in many ways to the patent area, that the transformation of antitrust law was not the result of the private bar. It wasn't the result of the government. It was the result of the academy. And it would be interesting to see to what extent that academic literature by people such as Arita and Turner was based on these theoretical economic considerations, and to what extent was the result of more practical suggestions. I mean, my impression is that it sometimes got pretty theoretical and was influential nonetheless. But I do think there's a problem, and you ask the courts to do too much in the way of economic analysis in connection with these cases. And a lot of us, myself included, don't think that our function goes quite as far as you might think.
This morning we had a discussion about the difference between setting bright line rules and formulaic interpretations of the law versus these more sort of nebulous standards like what came down after eBay and MedImmune. And I guess I'm asking, is there sort of a chicken and egg problem with the way litigants come to you and argue, since there were more bright line rules in the Federal Circuit, whether the presence of those rules is pushing litigants to stay away from policy and argue more on hard facts versus giving you the policy arguments that they may raise at the Supreme Court where they think they may have a chance for sort of a broader interpretation.
Well, I don't know. I don't think that there's maybe my perception is wrong, but I don't see it as a rule base that either we're more favorable or less favorable to rules. And the Supreme Court's question of what what the standard, what the rule is going to be. And one of the interesting things about patent law is in how many areas there's the totality of the circumstances test, which the Supreme Court in PAF, at least in the context of the on-sale bar, indicated it didn't think was very useful. So, you know, to some extent, there is a problem of a need for predictability in this system so that you don't have as much litigation. On the other hand, the rules that you develop have to be sensible rules which are helpful in resolving the cases and in an appropriate policy framework. You know, it's hard to generalize about it.
And you may not want to answer this, but in the most in the Seagate case, that
Probably I don't.
en banc was just granted, but, and I may be reading this wrong, but it appeared that unlike previous en banc cases where you essentially allowed anyone to file amici briefs, in this one it appears to say you need to follow the rules of getting permission of both parties or permission of the court before filing. And I wondered if that is a shift in policy, or if it's a one-time thing, or just an unnoticed thing.
I think I'm not going to comment on that.
I have a follow-up. I mean,
The follow-up is why don't I want to comment on it?
You mentioned the government, having the government potentially giving some advice on how to decide certain cases. The Supreme Court finds that very helpful. And what the Supreme Court does is ask for the solicitor's view. And I wonder, and of course we have the one example where it was worthless in your case, in the Festo case, but I wonder if there's a potential for, especially if you think there's a case that might have some public interest stake, or something that the Patent Office or the Solicitor's Office might be able to help provide third-party advice for whether that might be an avenue to get additional input in cases.
Well, we've done that. I think in some of the in-bank orders, we've specifically invited the government or the PTO to file. And occasionally we've done that also in panel cases, though that is less, I mean, panel cases in which the PTO is not a party, that's less common. I personally think it would be beneficial. What I haven't seen, and maybe I'm mistaken about this, what I haven't seen are cases in which the PTO on its own initiative has filed amicus briefs, unless, their funding is somehow involved in the case. But in terms of providing guidance, views on substantive patent law issues, I don't know what the reason for that is, but there does seem to be a reluctance to do that without the invitation.
Well, it's an interesting, there's interesting parallels. Often when you're reviewing a case, at the same time the Patent Office is reviewing the case through a reexamination. And right now, the two processes essentially ignore each other to a large extent. And there may be ways to bring those together. I don't know if
I don't think I want to answer that one either. It's an interesting question, though. I mean, it's a significant question. Yeah.
And this is, I know you weren't asking me the question, but as you might be aware, the National Academy of Sciences report recommended or suggested that in certain cases where a challenge was brought to validity, be referred to the Patent Office, which would be a way of bringing the Patent Office into a validity determination. Which is slightly different from the question you were asking.
Yeah, I think he's referring to a situation where you have this dual track, dual challenge to the validity of the patent.
Obviate the need for a dual challenge, and you that your challenge is going to be referred to the Patent Office anyway. Other questions? Yes.
Specifically regarding the metabolite case, it seems to me highly unusual, if not perhaps unique, for the Supreme Court to grant cert, have the case fully briefed, and then decide that they don't agree the case. And it seems that it must signal something that the Supreme Court, or some change in the Supreme Court's behavior. Do you have any feeling for what that change may be?
Well, I'm not sure that it's unique. I mean, that does happen occasionally, that the court dismisses cases as improvidently granted for a variety of reasons, including the fact that they don't think that the case really raises the issue that they thought it raised. What's perhaps unusual about the metabolite case is that that problem was not one that surfaced after the cert stage. It was apparent at the cert stage, and what caused them to decide to grant cert and then ultimately to dismiss it. I mean, it's a fascinating question, but it's not one that I can shed any light on.
Well, I have one question. I suppose I can now take my role as a participant in the audience. And that is, you've suggested that and this kind of follows up on stuff that Dennis was talking about, you suggested that, and it's clearly the case that in the context of the Supreme Court cases, the government gets very heavily involved, and the PTO might get more involved in some of the cases that you hear, perhaps. As far as I can tell, though, and this goes back to the administrative law question, at least with respect, it is true that the PTO doesn't have substantive rulemaking authority, but generally speaking, even in the absence of substantive rulemaking authority, most courts will give some deference to an agency's position, whether it be called Skidmore deference or, and my sense is that the PTO feels, well, what it feels is irrelevant, but there might be some impression that everything is reviewed de novo by the Federal Circuit anyway, so, you know, the PTO's position may not be given any special weight by the Federal Circuit. Is that something that you have any thoughts on? Or because, for example, the In re Fisher case where the PTO had those utility guidelines, the opinion talked about the existence of those guidelines, but in theory, at least, that shouldn't have been a Skidmore deference situation, but there was no mention of that in the case.
Well, I can't answer why.
Right, not exactly, but I mean, let's talk at a more higher level of abstraction. I mean, is that an appropriate, standard to be using with respect to?
I don't know. I think in some contexts it is, but when we're talking about an amicus brief from the PTO, I don't think probably that we're talking about a Skidmore deference situation. But which isn't to say, the point I'm making is that the PTO's views are important. They're very useful. The PTO is an important agency, and they should be giving us their views. And the assumption is, my predicate to that is that their views are entitled to be considered very carefully. So it's kind of like Skidmore deference, but I don't think it's formal deference when you're talking about an amicus brief.
Well, it looks like we have exhausted our time, and I want to have us all thank Bill Scheich for
There will be a 10-minute break before the afternoon session begins.